I'm Meredith Johnson Harbach, Professor of Law at the University of Richmond School of Law, and I'm here to unpack the United States' new lawsuit against the state of Texas. At the heart of the dispute is Senate Bill 8, also known as the Texas Heartbeat Act. The new law prohibits almost all abortions in Texas after doctors can detect cardiac activity, which typically happens at around 6 weeks into a pregnancy before many women realize that they're pregnant. There's no question that the law is unconstitutional under decades of Supreme Court case law, ruling that states cannot prohibit abortions prior to the viability stage of pregnancy, usually between 22 and 24 weeks. Now, normally, parties challenging the constitutionality of such a law would be able to file a lawsuit in federal court against the state officials in charge with enforcement. However, the Texas legislature structured the new law in an unusual and unprecedented way that makes it procedurally difficult to challenge. Rather than empowering Texas officials to enforce the abortion ban, the law instead deputizes regular citizens to enforce it. The law allows anyone other than a Texas official to sue anyone who performs an abortion after 6 weeks and anyone who assists in the performance of such an abortion. Successful parties receive $10,000 in money damages. The effect of this structure is to transfer responsibility for enforcement from state officials to private citizens. Practically speaking, it prohibits abortions while also preventing a federal court from blocking the law because the law is enforced by private citizens. The procedural structure of this new law has been successful in frustrating judicial review in federal court. Over the summer, a group of Texas abortion providers and others initiated a lawsuit in federal court in Austin against Texas state judges and clerks who would presumably be enforcing the act once civil cases were brought. On August 30th, the plaintiffs in that case filed a request for emergency relief with the Supreme Court of the United States, asking the court to block the law. A few hours before midnight on August 31st, the Supreme Court declined to do so. Importantly, the court acknowledged that the lawsuit raised serious constitutional questions. Nevertheless, because of the procedural complexities created by the enforcement structure, the Supreme Court declined to block it. Consequently, Senate Bill 8 went into effect in Texas on September 1st. Since then, Texas abortion providers have stopped performing abortions at or after 6 weeks, meaning approximately 85 to 90% of abortions in Texas have been halted. Texas women seeking abortions now have to travel long distances out of state, if they have the resources and ability to do so, to terminate their pregnancy. Because the structure of the Texas law successfully avoided review in federal court, last week the United States sued the state of Texas. The United States argues that Texas has unconstitutionally banned abortions after 6 weeks, while also obstructing the ability of women and providers to challenge the law in federal court. The U.S. has asked for a declaration that this law is invalid, as well as an order preventing Texas officials and any private citizen who could sue under the law from enforcing it. So what's next? On Tuesday night, the United States filed an emergency motion in this new lawsuit asking the federal judge in Austin to block enforcement of the law. That hearing is scheduled for October 1st. Until then, the law remains in effect, and almost all abortions in Texas continue to be banned. In the meantime, the Supreme Court is set to hear oral arguments this fall in a different case, challenging a Mississippi law which bans abortions after 15 weeks. This case presents an opportunity for the Supreme Court, with a new, more conservative composition, to overturn Roe v. Wade.